like you said, my name's Todd Sivia, and I own a law practice in Edwardsville. And I primarily focus in asset protection. So I work with business owners dealing with business, real estate, and estate planning type of issues. One of the things when I talk about estate planning is, that I can guarantee one thing, and that is that 100% of the time you guys will all die.
Yeah.
We don't know when it's going to happen. For example, just that chiropractor, he died at age 31. So, and you see stories in the newspaper that an 18-year-old dies or a 20-year-old dies. So it does not have to happen. And I just was talking to a client. Client's son came in yesterday. His father had died at age 58. And it was all of a sudden, it was a heart attack, and he was gone. There was no plan, there was nothing to think about. And usually when I deal with estate planning, it's usually, I usually get people that say, I'm going on vacation, I might as well go ahead and get a will. Or, we finally got the kids out of the house, we can figure out, guardianship, we don't have to worry about guardianship anymore, so it should be fairly easy, and therefore, now we can go do estate planning. So it's usually, I usually get the 50-year-olds, 40 or 50-year-olds to say, okay, it's time for me to do planning. So when we talk about plans, what should you have from a general perspective? As soon as you turn age 18, every person in here should have a power of attorney. A lot of people think, okay, well, I can my child turned age 18, I can still make financial decisions for him, I can make healthcare decisions, I can determine if I can pull the plug or not on the child that has given me hell over the years. But you can't. As of age 18, they are considered to be a person that is able to make their own financial decisions. And therefore, the only way you're going to be able to make financial decisions for them or healthcare decisions is if you have a power of attorney. And a lot of people also think, well, I'm married. My husband or my wife can make the financial decisions or healthcare decisions. Now, doctors will give you a lot of latitude with making those financial decisions without a power of attorney. But when it comes to certain end-of-life care issues, you need to have that power of attorney, not only to give a clear direction of what you can and can't do, it's very important. So some examples would be, I want to pull him off a respirator. I don't think he's going to live. I don't want him to, I don't want my spouse to continue to be set on this respirator for a long period of time. Can't make that healthcare decision without that power of attorney. So those end-of-life care issues are very important. Same thing with living wills. There's a great case, and it got a lot of national attention 10, 15 years ago. And the case was, the gal's name was Terri Schiavo. And Terri Schiavo, the issue was, she had just, if I remember the case correctly, she had just gotten married, so it was a new husband. Parents wanted to make healthcare decisions for her. Husband wanted to make the healthcare decisions. And the choice was, do I want nutrition to be added to my life to keep me alive? We all know that in 3 days, if we don't have fluids in our body, we will die. Within 7 days, if we don't have food in our body, we will also die. Or 21 days, sorry, 21 days. So the question was, do you want nutrition? And if that was the only thing that was keeping you alive, and you were brain dead, other than that, is that what you wanted for your life? And that was litigated. It went all the way up through Florida Supreme Court and on to the US Supreme Court that punted it back to Florida and said, you guys make the decision. And there was no clear direction. And a living will, which is a very simple document, would have cleaned up the whole mess. So having that document is very important. And I give everybody, this is my favorite piece that we've ever created, is your last will and testament, if you choose not to draw a will up. This is what the state statute says.
And these are all the defaults that would fall to?
Yes, this is all the defaults. So if you don't have any kind of planning mechanism, this is what you fall down to. One of the most glaring is my wife doesn't get, my spouse doesn't get my other half, 100% of my estate. They only get half. So now the children, they have to divide their estate in half and give the children one half of the estate. So a lot of people think, oh, well, my wife is just going to inherit. Well, it's not an automatic. Here's a couple of things that a lot of people say, okay, I want a will. With wills, what wills do is they are directions to your executor to be processed by a court, and that's called probate. So you go through the probate process, and you have to have a court approve the will and make sure everything is transferred into the probate, into the estate. Probate is a 6 month to a 2-year process to transfer estates. Typically that deals with anything with assets over $100,000 or real estate, which are the two rules that apply. So if you own real estate or you have $100,000 in value, you will automatically go through probate. A lot of times when I'm doing estate planning, I hear of, oh, let's transfer, we want to get the house out of mom's name before she goes into nursing home. I hear that quite often. What happens is twofold, and let me give you a short little story. I had a client that came in after this had happened. She had transferred the house over to her son. Son and his wife decided to get a divorce. Son, in divorce decree, the judge awarded mom's house to ex-wife because they had two houses. Ex-wife filed eviction papers to evict mom out of her house. So mom is now homeless because they decided to move the house ahead of time. There are other proper ways of doing that that would keep mom in the house and plan for estate plans. But a lot of these self-help items are usually not the best course. In her case, unfortunately, there was not much I could do for her besides try to settle something to keep her in for a little bit longer. There's definitely never an easy fix. A couple things that that a lot of people don't talk about. Is from a business planning perspective, or actually IRAs. we talk about IRAs. 90% of the time, in society, we're moving away from these full pensions anymore, and we're going to a 401k process, where a lot of people have 401ks or IRAs, and they have a lot of money into your estate plan. And there's all kinds of different ways associated with that, if you do some planning, a lot of times what will happen is somebody passes away, they have their IRA, and everybody pulls the money out. That's what I usually see is they pull out, say it's $100,000 and the person's 35 years old. They're left with, because it's an IRA, they're left with about $60,000 because of all the taxes that you have to pay associated with it. If you do some planning, you can keep them into that IRA for a longer period of time and force them to take it over their lifetime. If they take it over their lifetime, it turns out to be their distributions on a normal rate of return is about $1.2 million. And if you force them into what's called RMDs, or required minimum distributions, you can save them up to $200,000 in income tax by taking it over their lifetime versus taking it one lump sum. So there are different ways from a planning perspective that you can protect those assets or force them into taking it over their lifetime, which keeps the money creditor protected and things of that sort. One of the other issues that just a recent thing where a lot of estate planners are talking about is something called aid and attendance. How many are veterans? Okay. If you're a veteran and you're over 65 and you need 2 out of the 5 assistances, so for feeding, for clothing, for cooking, for dressing, and to go to the bathroom, you need assistance 2 out of that 5. You qualify, you and your spouse qualify for up to $2,000 a month in long-term care. But there are some caveats with that. You have, with certain planning techniques, you can get your assets down to about $80,000 to qualify. So there are definitely options out there with regards to estate planning. And I want to be within my time frame. Am I good?
Yeah.
Okay, all right. The other issue that I've seen commonly, anybody gun owners that want to be open about it? One of the things with gun ownership is, and I see this occasionally, where you have a husband and wife. Husband collects guns, likes guns, they have their FOID card. Wife does not have their FOID card. Most estate planners are not thinking about this, but if you don't have your trustee or your executor be be able to possess firearms, it is, depending upon how, and they take possession of those firearms, it's typically anywhere between a misdemeanor to a felony. With certain firearms, it could be classified as a federal felony. So, and the certain ones that I'm thinking about, it's a 10-year sentence with a $100,000 fine. So taking possession of firearms is an issue. We want to make sure that we're heading that off and making sure we've got somebody that's going to take possession of firearms without being illegal. So we want to make sure that's taken care of. Business owners. Typically with business owners, we always like to make sure that they have a plan. You know, we all think that I'm going to run this business until my end of days. But a lot of times, you know, we die suddenly. For example, the chiropractor. He had at least 2 businesses that he was running. And so he had a chiropractic office, he had another business that he was running, and if you don't have a plan, there's no value, your business value significantly reduces as the days go by. So for a chiropractor who's now passed away, the value of your practice within the first 30 days will significantly decrease, because there won't be any patients that will be calling the office because they've seen on the newspaper that they've passed away. So having a pre-plan, you know, is the best way. You know, I've set up situations where different professions will work together, and they may be, for example, I've got 3 orthodontics that I'm working with right now, and all 3 of them own their solo practice, but we get them together and they have a plan in case one of them dies. So that there is a plan in place to take over and have that succession. It doesn't matter what business you're in, you always need to make sure you have that succession plan worked out. There was a great movie, We Were Soldiers, and there was a scene in that movie where you had a whole bunch of guys sitting on the helicopter, and the colonel comes up and says, and it lands, and he says, "Van, you're dead. What's going to happen next?" And he said, "You hesitated. Van, you're dead." So estate planning and succession planning is just like that, because you don't know when somebody is going to die, and if you don't have everybody knowing what to do if something happens, everybody's going to perish. You know, people that have been working for your business, they may lose their job because you don't have the succession plan taken care of.